Welcome to Queen City News Plus and Order in the Court. I'm anchor Brian Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
Yeah, Khalifa, good to see you again. It's been a while since we've been together here. I've been out on getting that total knee joint replacement surgery, and it's good to be back and seeing you here in the blue room with
I've been missing you, brother. I've been missing you. I saw you, I won't say limping, but you walked it gracefully.
Day by day by day. And, of course, it is good to be back in here doing some always got some great topics here for Order in the Court. We got three subjects that we're going to be talking about. Ghislaine Maxwell, as we're shooting this, taping this on a Monday here. She was in court, and she took the fifth today. We're going to talk about that. Also, we're going to be talking about Tiwana Brown, former Charlotte City Council member. She pleaded guilty in federal court today. But we're going to start here today with the first one that we're going to be talking about, and that is temporary protected status for Haitian immigrants is safe for now. And that's after a federal judge has ruled that they can stay in place, is protecting the status for Haitian immigrants right now. Let's talk a little bit about that. Break that down for us.
Yeah, this case has a number of things that it talks about, Brian. It talks about the First Amendment. You're talking about the Administrative Procedures Act. You have some history that's thrown in here, and you have a often quoted law school quote. So I'll start with some history. They start off in the opinion. This is the judge's words. On December 2nd, 1783, then Commander-in-Chief George Washington. You know you're in trouble if the judge is quoting George Washington in the beginning, right?
I saw that right off the bat, and I was like, whoa, we're going court right. George Washington right off the bat.
Not 1999, 1918, anything but 1783.
Here is
right?
a good history lesson for court.
I would just drop this gem on you right in the first two lines. America is open to receive not only the opulent and respected stranger, but the oppressed and persecuted of all nations and religions. But they go on to say that Department of Homeland Security Secretary Kristi Noem has a different take. Specifically, this opinion talks about how you may have the ability to say a number of things and call people the derogatory names and statements that Kristi Noem has made about these Haitian immigrants, calling them killers, leechers, and entitled junkies. But the judge disagrees with that statement, but says that Noem's First Amendment rights and protections give her the ability to do that. But she also says that there is something else. There is this Administrative Procedures Act that you have to make sure that you are following if you are an administrative agency. So was there a notice that a hearing would occur? Was there an administrative rulemaking process? Was there an opportunity for answers and questions? Was there a moment for people to give their feedback before you formulated this final opinion? And if you or the administrative procedure, and if you haven't, then you violated the APA, and thus any type of rule that came out of that would be void. The last point I'll say is that this is a walks you through what you're supposed to do by not being offended by speech, but looking directly at what the law says on the administrative side. This judge did an excellent job of giving a history lesson, yes, but making sure that, okay, I'm going to stick straight to the point, which is, have you violated the APA? And it seems like you have. And if you have, this law, this administrative rule has to be taken away.
So this court decision that came down, it was on February 2nd, and it's going to remain until pending further judicial review. Explain that process and when that will happen and what could happen then.
Well, they were asking, petitioners, these five individuals were asking for the court to stay, pause, not allow this administrative rule to take place until the underlying issue can be resolved, making a determination of do they and have they went through the APA policies that I've listed earlier before. Now, if they haven't done that, then yes, it will be no opportunity for this to be a formalized, promulgated final rule. So right now, the stay is in place. The next step can be quick or it can be slow. And also, the administration could appeal this U.S. District Court's ruling. So there are a number of choose your own adventure, pick your poison or path that you could go with this. But I say that right now, my quick reading of this opinion, because it was 83 pages, the parts that stuck out to me is that this temporary protected status, and that's why the judge put that George Washington quote in there. These are individuals that are in their home country, that are fleeing persecution, that have come here to the United States, and that, as this judge has mentioned, are successful members of society. So much so that the judge says that these folks that are part of this program bring in an estimated $5.2 billion with a B dollars in taxes annually. So they're saying these aren't people that are coming here and milking off or leeching off of society. This group of people that come here under this TPS program are folks that are productive and are paying into our tax benefits.
So one of the things, too, is that this was a situation with very scathing remarks by the Judge Reyes here, Anna Reyes.
Yeah.
And she says Kristi Noem, Department of Homeland Security, she complained that it puts a strain on unlawful immigrants into our immigration enforcement system. Some 352,000 lawful immigrants into unlawful immigrants overnight. So, and one of the things that the judge wrote, this approaches many things, and the public interest is not one of them.
Yep. I mean, so that's more to the injunctive standard. When you're looking to stay or stop something in an injunctive capacity, it's likelihood of success on the merits, irreparable harm, public policy, and that weighing of the interest. So that judge was hitting on both of them, Judge Reyes. But I would say that the judge was not flattered in or convinced or conveyed by Kristi Noem's arguments at all. There's an old adage, and this is from the opinion. In conclusion, this is how it starts. There's an old adage among lawyers. If you have the facts on your side, pound the facts. If you have the law on your side, pound the law. If you have neither, pound the table.
Pound the table. I've heard that from my sister-in-laws who are both lawyers.
Right.
And they always talk about the same thing. You know, pound the facts or pound the table.
I learned it in law school. So for me, this was hilarious to read. But the judge is saying Kristi Noem has neither. And so she pounds X. The 21st century equivalent of the table. That to me was craftily written, but something that I in law school remember hearing my professor say a number of times. Obviously, they weren't talking about X; they were talking about the table. But it was a good approach to say you failed to make an argument, you failed to be able to defend your position, and now you're making an argument that is not based on the rule of law, court case precedent, or anything like that. So for me, this is a cookie cutter example of something I would have loved to have given as a law school professor to test my students to try to pick out, well, were they able to find the APA portion of it? Were they able to address the First Amendment argument? Were they able to address the Fifth Amendment argument? If they were able to address these arguments, this would be an easy exam. But if they missed them, like some people may have, it could have been hard.
Well, one of the things, too, going forward, does this affect any other, because of the ripple type of effect, any other immigrants, not just because of this status here for Haitians, but what about anybody else?
Well, you got to remember, there are, number of cases, not a handful, but almost hundreds of cases that are out there that individuals, mostly nonprofit organizations, these organizations are bringing lawsuits against the federal government for immigration type of cases right now. So the Trump administration is being sued in federal court, in multiple states, in court of appeals. Cases are going up in front of the Supreme Court. So I don't think about a ripple effect, but what I can say is you have seen a concerted effort from United States district courts to ensure that they stuck to the rule of law. When a case comes before them in these courts, they're asking the litigants to ensure that they are maintaining what the standard is, at least, again, on the U.S. District Court's level. I can't speak to the Court of Appeals because each circuit would be different. The Supreme Court is doing a number of different things, and so each case will be case by case. But it seems like the district court judges are making sure that when these challenges are brought, they're addressing them as quick as they can. If there's a state that needs to be put in place, they're allowing it to be heard and moving forward.
All right, we're going to leave that one right there, and we'll keep following that for sure. Coming up next, we're going to be talking about this woman right here, former Charlotte City Councilwoman Tiwana Brown, as she pleaded guilty in federal court today for fraud charges. And we'll have more on that coming up. You're watching Queen City News Plus and Order in the Court with Khalif and Brian. All right, welcome back to Order in the Court. As court is in session right now with Khalif and Brian. As we were alluding to this right before the break, Khalif, former Charlotte City Councilwoman Tiwana Brown, she formally pleaded guilty in federal court today in connection, that is Monday that we're taping this, to connection with the COVID-19 relief fraud scam. And so during that, she conspired with her daughters to apply for these, you remember those payment protection loans or paycheck protection loans that we had out during COVID? Well, the federal government said that she abused those. And now she is, after being very defiant, when the indictment came out, she has pleaded guilty of the court documents say that she is admitted to, yes, I did do this.
You are mentioning those PPP loans that a lot of individuals have now since been either indicted or convicted on. And so she, when originally charged, like you mentioned, was extremely defiant, was making the statement that, looks, and I'll have my opportunity to prove my day in court. and standing boldly that she wanted to have an opportunity to do that. But this happens a number of times in cases, not when individuals are elected officials, but anytime a defendant is charged, if they think they have an opportunity to try to prove their case in the court of public opinion, but in court, they'll do that. But then when you meet with them and you start giving them the discovery, or in this federal court case, you start giving them the information, that what they actually have on you, and you start to recognize that, okay, if convicted for one count, I can do 20 years. I could have to pay back $250,000. If you start explaining that to your client, and there is not a legitimate reason around it, it's not, hey, this was not me, and I clearly did not do this. Ultimately, that tone does change, and the demeanor shifts, and it goes from, okay, I want to have my day, to I don't want to go to prison. And those are the types of conversations that happen when you're facing significant time. And so this was something that I anticipated from the very beginning. I say it all the time. U.S. District Court, U.S. Attorney's Office has 90+% conviction rate, either plea or trial. And so you walk in there recognizing if they're charging you and it's been indicted by the grand jury, it's extremely likely that they will convict you going forward. And so you're weighing, do I have a legitimate defense? And if you don't have a legitimate defense, if you don't have some type of smoking gun, even though it's not your burden to prove your innocence, you need a defense to what the government is going to bring forward in terms of what they're saying you did. And if you don't have anything, yeah, that's what we get as a plea. So they produced this plea, and it was filed January 29th. So we already had an opportunity to review this plea prior to her going to court today. She just formally accepted and entered her plea, recognizing that a couple of things. Hey, I'm understanding that, hey, I could go to prison for 20 years. Yeah, this is a negotiated plea. Yeah, the U.S. attorney and my defense counsel have come with some agreement, and we stipulated, agreed to a number of things, and I'm accepting the responsibility for what I did.
You mentioned 20 years right there. No sentence was imposed during today's hearing, and the sentencing date has not been set yet. But what are the guidelines for a crime like this and taking from the federal government some $40,000, I think it was, in the PPP loans? What will be considered going forward? And also, she is a convicted felon, having served time back in the 90s for fraud in and of itself. So what does that play? How does that play a role into what happens with her sentencing going forward?
Excellent question. In the federal process, it's not like our process here in North Carolina, where if you're convicted, most of the time the judge that's trying the case will sentence you right there on the spot, or if you're pleading, they'll sentence you on the spot. In federal court, you will enter your plea at that hearing, and then there will be a window, and then at a later date, you'll come back, and then there'll be an opportunity for the judge that's overseeing the case to have a sentencing hearing. And folks will make arguments for the judge staying within the sentencing guidelines. Folks may make arguments for the judge to depart the sentencing guidelines, and the judge will ultimately make a determination of where they will land with the sentence. But what happens in that window, that moment I talked about, that's in between the break, there's a pre-sentence investigation that happens. Probation officers will meet with the defendant and have an opportunity to review a number of things with them: childhood experiences, family factors, education, employment, criminal history, finances, physical and mental health, alcohol and drug use. And so those are the types of things. When you say she's a prior convicted felon, the judge will receive this summary, this report that gathers all the information during this pre-sentence investigation, and they'll have an opportunity to see not just a snapshot, but a bright picture of who this person is they're sentencing. I think the federal government does it better than anyone else in terms of how they handle sentencing, because it is based on the individual. It's not something where, okay, I've seen this type of charge before, this is what I sentenced them to. Yeah, we have our range, but I still need to know who that person is. And so this is clearly the easiest way for me to get a determination. I don't, as a judge, have the time to sit down and meet with the person, but this probation officer can. And when they meet with them, they'll go over, all of their history, school records, military records, employment history. I mean, they're going to go through everything to ensure that this person is a good candidate for, as she said, a probationary deal. They may make a recommendation that, hey, Your Honor, it's maybe not within her interests, or maybe her criminal history doesn't allow her to get there. But this is something that happens in every case that comes into federal court, and so it's a part of the process that I appreciate.
During this time frame, if you had a client like this in this position, what are you telling them to do?
Well, I mean, obviously, be honest and forthright with the probation officer. Tell them everything they want to know, because if you lie, they can go find it, obviously. And then second, me as the attorney, I'll have an opportunity to review it before it goes to the judge. So, yeah, they do this paperwork. They'll go meet with the probation officer. They'll summarize and submit a report to the U.S. attorney and to myself. And then before it's submitted to the judge, I'm looking at it. And if I see anything wrong, I see anything misleading, I see something that they failed to tell, I'm saying, hey, let's go ahead and get this corrected, because we want to ensure that that pre-sentence investigative report is accurate. We want to make sure that you didn't you didn't mislead them, you didn't withhold, that you gave them all the statements that needed to be made directed to your case.
Yeah, and one of the things that is to note here, too, is that Tiwana Brown, when she was indicted back in May of last year, she was a sitting city council member at the time. She was very defiant in saying that she was not guilty of these charges, and then she lost in the election back in the fall and was unseated during that time. So it's certainly a fall from grace for Tiwana Brown to have here, but legal proceedings, you're definitely going to have to be hopeful and also follow the lawyer's instructions going forward.
Well, I mean, when you talk about fall from grace, remember, as someone that has been previously convicted, she recognizes what it looks like to be a part of the criminal justice system, and it's both ends, the punitive side and the rehabilitative side. And so because there's a rehabilitative side, she's shown that you can go to prison, and her company's called Beauty After Bars. That's something that she says is an opportunity for you to have a second chance after you go to prison. And so because this criminal justice system is supposed to be two sides of the coin, this isn't a permanent fall. This is an opportunity for an individual to learn from the lessons, and that's what our system is made of.
All right, we're going to leave that one right there and keep following Tiwana Brown, and when her sentencing comes up, we'll talk about that. But now let's talk about somebody who is already in jail, in federal prison, and that is Ghislaine Maxwell on the left, confidant and cohort of Jeffrey Epstein in a sex trafficking case. She has pleaded the fifth in talking with congressional leaders today, and we'll talk about more on that one coming up after the break. Welcome back to Order in the Court. You got Khalif and Brian here as court is in session today. Last topic we're going to be talking about here, Khalif, and that is Ghislaine Maxwell, tied with Jeffrey Epstein. So the sex trafficking case, she is serving a 20-year prison sentence right now. But she, in light of all the Epstein files that have been released over the last couple of months, she has refused to answer questions during a closed-door congressional deposition here Monday, again, as we're shooting this, prompting a lot of criticism from House on both sides, bipartisan criticism.
Yeah, but the writing was on the wall. She this originally, when asked to come and speak before Congress, her attorney said that under no circumstance would she speak unless given a deal. And this was months ago. So now the fact that she's come and she's appeared virtually, but appeared and had an opportunity to speak, any legal scholar that was watching recognizes that she could not go up there and speak truthfully as she wants to.
This doesn't come as a surprise to the legal profession.
Not even a little bit. And it should have come
just to the people in Congress today who are conducting everything.
I don't know if it's a surprise to them. I mean, because her attorney responded and said this, that under no certain terms would she speak unless, and he said it today, unless you gave her a deal. He says, yeah, she'll speak, but she'll need a deal. And because they weren't willing to give her a deal, this is what we get. This was anticipated. This was not like oh, wow, she told us she was going to talk today, and then she appeared and then didn't say anything. You asked me to speak. I told you if I come, I won't say anything. I actually come and don't say anything. There shouldn't be a surprise. This is like when I get a juror witness prepared, and then they get on the stand and the DA starts to ask them questions. I'm like, yeah, those are the questions that we went over. Like, there was nothing extra. It wasn't any type of curveball. This wasn't a curveball. This was right down the middle. Now, if they wanted her to testify truthfully and give an accurate account of what happened, you got to give her a deal. She has a pending case that she's trying to figure out how to get out of prison for. So her attorney, I think, would be committing malpractice if he allowed her to go to court, to this oversight committee hearing.
And answer questions.
Yeah. If you go there and answer questions, guess what? Those questions and those statements can be used against you later.
Well, she has asked for clemency from President Trump. Maxwell sat down with the Deputy Attorney General Todd Blanche back in Florida. When she was there for a 2-day interview. Then she was moved to a low security, more of a country club type of prison in Texas now, which leads to a lot of people to speculate about what is coming down the path here for Ghislaine Maxwell over everything.
This is the weird part about this, Brian, is it gets super complicated and muddy because you're asking her to testify about things that she did in the past where she's already been in prison for, right? And she's appealing and has that case pending. But she's asking for clemency for someone that could potentially be involved. And so I think it's so many complicated layers in there that I don't know how she can ultimately get a deal from the Department of Justice or get some clemency from President Trump, because if he does that, that triggers her speaking, which ultimately could lead to her naming him, in some type of documents later. And so I just don't, because there are so many different layers. If I'm advising the president, I'm obviously not advising him to grant her clemency. If I'm advising her and representing her, I'm not advising her to speak truthfully without clemency. So I think we're at like one of those, meeting, like where it's just, you guys can never come to an agreement. I don't think there is a resolution here that you can get to in court that will allow them, or I should say her, to be able to speak, unless her case miraculously disappears. Now, if she wins her Supreme Court case, then yes, ultimately, she may be able to come back and testify because now that case is gone.
Yeah, committee chair, Republican James Comer out of Kentucky today, who conducted the hearings along with several others in that committee, said they were very disappointed about her not answering questions and pleading the fifth. They were not surprised by that, but also said after listening to some of the sex trafficking victims of Jeffrey Epstein, he would be very, very disappointed as well if clemency were to be granted.
And that's why I say it's so many complicated layers.
How she, in his words, that she was some of the really bad criminal acts that were committed.
Yeah, I think that today was a day where a number of things were learned. In this hearing, you learned that when an attorney gives you the foreshadowing of what their client would state, that you probably want to listen. Because oftentimes the DA will say, hey, client going to plea or your client going to reject the plea. And that helps them to say, if I say, yeah, my client's going to plea, then they'll bring the family in and they'll have the family ready. But if I say, no, my client's not going to plea, they won't bring the family. So I'm kind of tipping my hat to at least allow them to do their job. Well, in this scenario, it's the same way. Her attorney gave them guidance early on and said, no chance that she pleads or talks unless there's a deal. But what I think learned more than anything was the opportunity on Capitol Hill for those two congressmen to get an opportunity to view the unredacted files. So while this was happening in one portion of Congress, you had the other part where those members starting today were being able to view those files. And so I think that was probably more productive in terms of the process than what happened with Maxwell. This was foreseen for sure. And I think there are a number of other individuals that will come before this committee and probably do the same thing. Remember, our Fifth Amendment rights are there for a reason. You have a right to not self-incriminate. You don't want to put yourself in a position where now I've made a statement that can negatively affect any potential case, any current case, any past case. And so it's always in your best interest to seek legal counsel. And her legal counsel has done exactly what he's supposed to do by advising her to avoid saying anything other than, I plead the fifth.
I plead the fifth, and we will certainly watch this case and see where this one's going to go forward with Ghislaine Maxwell. And Khalif, always good to talk to you here in Order in the Court. That's going to wrap it up. Court is out of session right now, and I always appreciate you. And then we're going to get more of your expertise next week as we're going to wrap it up here in Order in the Court. You're watching right here on Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.